The Pro-Teeth Whitening case was a judgment of the Federal Court of Australia on appeal from the Federal Circuit Court, and it's an important case for both consumer law and administrative law. The appellant, Pro-Teeth Whitening Australia, sold teeth whitening products containing 12% hydrogen peroxide, which was double the limit the Australian Competition and Consumer Commission considered safe, based on the Poisons Standard 2011. The ACCC asked Pro-Teeth Whitening to voluntarily recall the products. The company refused, saying that it had received no complaints about its products and that other teeth whitening products on the market had similar concentrations of hydrogen peroxide, but they had not been required to recall their products, and it was unfair that dentists and beauty therapists could use teeth whitening products with more than 6% hydrogen peroxide, but home products could not. The ACCC took action, and the Minister issued a compulsory recall notice under Section 132J of the Australian Consumer Law. This was obviously a disaster for the company, which took action in the courts. The court found that to issue the recall notice, which is the strongest action available, the Minister had to consider two specific matters. First, whether there is a risk of serious injury to consumers, and also whether that risk is imminent. If those factors are not there, another course of action, such as a product warning or a ban which doesn't involve a recall, would be preferable. The court found that while the ACCC had been communicating regularly with Pro-Teeth Whitening about the safety of its products, the rules of natural justice, which is an administrative law concept, required that the Minister should specifically invite Pro-Teeth Whitening to provide its views on whether its products carried a risk of serious injury and whether that risk was imminent. The court said, the Minister did not notify the company of these further matters. Neither had the ACCC. If the ACCC had done so, the appellant would not be in a position to complain of any denial of natural justice, but it did not. The court did not decide whether the teeth whitening product would cause serious injury. However, because the Minister had not given the company a chance to be heard on these issues, the compulsory recall was invalid. The Minister's consumer protection powers are very strong, but even the Minister must follow the rules.